This hearing spirals fast, from a routine rent dispute into a full judicial shutdown. What starts as a landlord trying to recover unpaid rent turns into a lesson on procedural abuse, duplicate filings, and judicial patience running out. The judge immediately makes one thing clear: you don't get multiple bites at the apple just because you didn't like the first outcome. As tensions rise, confusion over escrow, overlapping cases, and unpaid rent collide, while the court repeatedly asks one brutal question: why is this case even here? Stay with us, because by the end of this hearing, one side walks away empty-handed, and another gets an unexpected win.
I am not dismissing the case. I made that clear the last time. I went through it with the parties. So to the extent, counsel, there is a motion to dismiss that case, it is denied. Why would I permit a judgment in this case when rent has been paid and was part of the other case I just now didn't dismiss? Why would I do that?
Good morning. My name is Edward Mall, MAHL P27115, appearing on behalf of plaintiff in case that ends in 3911.
Your name? Thank you. All right. So where are we on this case? 8.
This is second hearing on the case that ends 3911.
I'm taking that now. Right, but we've got a problem because there's this other case. Do you know about that one, counsel?
Yes, I've heard about that case. Our client has been dismissed, and Ms. Anderson does not wish to proceed on that case at this point.
That who?
Ms. Anderson does not wish to proceed on that case at this point.
Okay, but the defendant in that case didn't consent to the dismissal, and the court did not dismiss it.
But we're moving that. Go ahead.
Question. Was there a counterclaim? I don't know about it.
She's moving to dismiss that case at this point. That case involved damages and violations of the lease other than rent. This case the second case involves purely unpaid rent. So she's asking to.
Which is the same as the other claims that were brought up in that case.
The other one was mainly for fraud. And I never got a counterclaim, so
Clearly, throughout the entire proceedings, she filed effectively what have been counterclaims and defenses to the actions and claims against you in the first matter.
What did I
am not dismissing the case. I made that clear the last time. I went through it with the parties. So to the extent, counsel, there is a motion.
This is the legal heart of the problem. The judge is clearly irritated because the same rent issues are being litigated twice, once in a pending case and again in a newly filed one. Courts do not allow parallel cases covering the same claims. It's inefficient, unfair, and risks inconsistent rulings. That's not rhetorical, it's procedural law. Filing a second case doesn't create leverage, it creates exposure. From the bench's perspective, this looks less like advocacy and more like an attempt to game the system.
To dismiss that case, it is denied.
You wish to proceed with the proofs as to the rent?
Here's the problem, and I explained this to Ms. Anderson the last time. Why would I permit a judgment in this case when rent has been paid and was part of the other case I just now didn't dismiss? Why would I do that?
There's rent that's due that is not paid. So that's why the second case was filed. And there's unpaid water bills, and there were other costs involved.
3 months rent, water bill, court costs.
All of that was being handled in the other matter. So, as I was here the last time, I don't understand why I have this new case.
It was for the unpaid rent because she hasn't paid September, October.
Ordered escrow, what did you think was going to happen?
She hasn't paid it.
I said, Are you claiming that in the last case, there was no claim for rent?
The last case was for fraud.
Are you claiming that there was no claim for rent?
Yeah, there's claim for rent. And
Exactly. That case is still pending, which means the rental claims, which will go month to month, are still pending. And now I get a new case,
I thought you were gonna.
which just doesn't make any sense to me. At the last hearing, I told you it did not make any sense to me as to why it was filed. None whatsoever. And if you think what I'm going to do is take a new case, rule on that while the other case is pending, not going to happen. The other thing is, there's a problem violation of the court rules because she has to give, and I don't think she did. Well, maybe she did. For whatever reason, I don't even know why one would do this. Is that 7-6? The other one ending in 2176.
That's true.
This one.
Yes.
All right.
And I believe that white file as part of it. It's a 2 months.
So I don't understand why I have two cases.
Well, then let's proceed as the court wishes to proceed. Your Honor, you entered an escrow order in this case, was it?
Yes.
And I wish to advise you that
In which case?
The first case.
the first case, okay.
As for
I did.
It's not been paid for months. October,
What do we have as our escrow? Do you know?
3 months have been missed. Those have not been paid.
Miss Lyman?
Yes, I haven't paid the 3 months, but I have the 2267 going on this week, and October, November it will be in by the end of this month.
By when?
By the end of this month.
My client just checked with the court clerk today, and there's only $6,600. That's 2 months' rent.
I just said I will be paying the 2267 this week.
All right.
in October.
Escrow orders are not suggestions, they're court commands. When rent is disputed, the court often requires the tenant to pay money into escrow while the case is pending. That protects both sides. Here, the judge confirms there's only $6,600 in escrow, roughly 2 months, despite claims that more payments were coming. That gap matters. Non-compliance with an escrow order can trigger an immediate trial or even sanctions. This moment shifts the tone. The court stops debating theory and starts preparing for enforcement. At this point, the judge isn't negotiating. He's scheduling consequences.
Because it's an escrow order, the only thing that happens is I set it for an immediate trial if there's non-compliance. We were at the point of getting a decision on the case. Are the parties going to be ready to try this in a couple of weeks? Because I'm not trying it today.
Yes, we can be
Because
ready.
these pleadings are all out of order.
We can be ready to try it in a couple of weeks, yes.
Would you be ready?
Yes.
And you say you're going to have escrow cleared up by the end of this month?
Yes, sir.
2nd and 9th.
Yes.
Non-jury trial will be set December 9th, 2025, 9 a.m. on both cases. Why I'm ruling on the other one, I don't know. All right, thank you. Court does call the case of Lakestone Apartments versus Chartavia Michelle. Hello. Before you sit down, you can sit down if you want. You're gonna stand?
Yeah.
All right, it's up to you. Who are those little people?
My sons.
Grandsons for me.
I didn't care about you, did I? Did I ask about you? I just, you notice how you did that? just stepped on into the conversation? My sons. Hello, how are you two doing? You sure? Are you bored? Yeah? Wow. You didn't have to be so honest. Right. I don't have anybody from the plaintiffs here.
Okay.
So I don't know where everything is, but I set this for final settlement conference today. They're not here. You have a motion for me?
I request that they dismiss this, that this be dismissed.
This is the judge reasserting total control of the docket. With pleadings out of order and confusion on both sides, the court does what courts do best, imposes structure. A non-jury trial is set, both cases consolidated for efficiency, and deadlines become real. This removes uncertainty and forces both sides to prove their claims instead of arguing in circles. Judges don't like chaos, and they especially don't like wasted hearings. Setting trial is the court's way of saying, enough talking. Bring evidence.
Motion. Motion's granted. Case dismissed. You're welcome. You guys take care.
Thank you.
Sorry about the wait.
Okay. It was good. Thank you.
Was I really boring you? No. Okay. All right. Thanks. I feel better now. What?
Yeah.
The other, you said yes? He said, yes, I'm on my way out. I'm not talking to you, Judge. All right. Bye. Bless his heart. All right. Take care. The other one's gone. He was bored. 14A stands in recess.
My name is Annika Skibb.
Yes, I mispronounce it every time.
Okay.
Thank you, Your Honor. Your Honor, today's the date and time set for pretrial and violation of bond. As to the, would the court prefer to address the bond violation first?
Hold on a second. Got it. Okay, go ahead.
Would the court prefer to address the bond violation first or the pretrial?
Bond violation.
So, Your Honor, at this time, Ms. Skibb is not going to contest the violation. She is going to admit the violation for drinking and testing positive on the silver link.
And Skib, why?
Your Honor, I'm very ashamed because this mistake was absolutely not indicative of the work I've been putting in the last few months, regularly attending meetings, and I'm very involved in the AA community in this area. I did an assessment by First Step Referral Services and was advised to complete inpatient treatment, and this is not at all acceptable, but the idea of having to be away from my son and the stress of this case on me, I allowed it to get to me, and when I messed up, I panicked, but I am currently at Dawn Farm.
Do I have the violation?
And it is the 90-day program, correct? Yeah, so she's in the gold standard, the big one.
Well, I'm looking for my copy of the. How much were you drinking?
The day of the 20th, so the first day, I believe I had
The day of the 20th?
The day of the 20th is when I thought the report was sent from, Your Honor.
No, Ms. Gibb, have you seen the bond violation report?
I have not.
Have you had a chance to look at it? We discussed it, Judge, but we haven't.
Sorry, I was thinking about the 18th, Your Honor.
Yes,
On the 18th,
Yes.
you blew a .12.
I had had 2 drinks. Was immediately after, I believe so. I had, I believe, 2 drinks, possibly 3. I don't remember exactly.
Then immediately after that, basically through that was at 10:33 when you blew those numbers. And then basically into the early morning of the 19th, you missed your testing.
Correct, Your Honor.
Are you indicating to me on the 18th, you had 2 drinks?
No, Your Honor, I'm saying I don't remember how many. I believe it was 2 right before breathalyzing. I believe it was
This
That
is one of
next
the most
day,
jarring
PM.
moments in the video. A completely
You
separate
will
case is called,
a .09.
plaintiff doesn't appear, and just like
Correct,
that,
Your Honor.
it's over. Motion granted.
Like
Case
I said, I
dismissed.
panicked and I was
No
drinking
drama,
for
no
the
debate.
next
This contrast is powerful.
day. So
Earlier, the court
You
demanded
kept
strict
not
procedural
retesting
compliance.
as it's
Here,
required.
the absence of the plaintiff ends everything instantly.
And
Courts
then by
reward
9
preparation and
o'clock
punish
that
neglect.
night,
It's a reminder that showing up
you
isn't
blew a
optional,
.267.
and that sometimes silence is the loudest
Allen.
mistake of all.
And then how many did you have after that?
again, I don't know. Was a few drinks the next day as well.
What?
It was at least a few drinks the next day as well. I don't remember exactly how many, Your Honor. I'm sorry. I didn't measure.
Because then at 1, well, basically 2 o'clock that next day, PM, you blow a .09.
Correct, Your Honor. Like I said, I panicked and I was drinking for the next day. So
You kept not retesting as it's required. And then by 9 o'clock that night, you blew a .267. Mr. Allen. And you say now you're in treatment?
yes, I'm currently at Dawn Farm and I was in jail for 6 days.
Anything else you want to say?
Your Honor, Ms. Skip has been very honest and open with me about this and about her problems with her drinking. She is like I said, she is at Dawn Farm. From my understanding, I believe it is going to be effective, and correct me if I'm wrong, eager to get back on track. She is deeply regretful and remorseful of her mistakes. She's been honest with me the whole time, and I don't believe she's tried to hide this at any point. But we are asking that, Your Honor, that she be allowed to return to Dawn Farm rather than the custody of the county today.
And then what will I do with her?
Your Honor, I suppose see what happens at Dawn Farm after 90 days. She is inpatient. It is inpatient, Judge, if that makes sense.
Do I have it?
I'm sorry.
Do you have proof of that?
We don't have any. Do you have the written documentation here right now?
I have so I have documentation from the farm with me. I also signed a legal release of information to Mr. Bradell on Monday when I was admitted. I also
Right now, I don't have anything.
I have a peer with me that's from the farm that is also with me. If possible, we can call the farm. Whatever proof is needed, I will be able to get to you today. I didn't.
This is where accountability becomes unavoidable. 267 paired with mistests and vague explanations. Numbers don't argue back. The defendant admits drinking, but can't pin down how much or when, which raises red flags about control and honesty. Bond conditions exist to protect the process, and alcohol violations are taken seriously because they show immediate risk. The court isn't punishing relapse, it's evaluating reliability. And right now, reliability is slipping fast.
Realize that I needed more than the legal release of information.
This final exchange captures a central tension in modern courts: treatment versus incarceration. The defense asks for grace, pointing to inpatient treatment, remorse, and transparency. But the judge asks the hardest question of all: what happens next? Without documentation, the court can't rely on promises alone. This case shows how quickly freedom can hinge on preparation, proof, and follow-through. Courts will consider treatment, but only when accountability comes with it.